Hi, my name is Kwame Granderson, and I'm a real estate attorney. And I'm here to talk about some of the legal issues with buying at trustee sales. When you buy at a trustee sale and you take title subject to whoever's occupying the property. And that could be either the previous owner or a tenant. If the occupant of the property is the previous owner, they have fewer legal rights than if the occupant is the tenant of the previous owner. Because if the occupant is a tenant, you might actually take subject to the prior lease, and even if they only had a month-to-month tenancy, then you still might have an extended period of time before you're actually able to gain possession to the property. So what I typically recommend is that you absolutely drive by the property to make sure that the property is either vacant or occupied, so that you know what you're getting yourself into when you take title. The other legal concern that you might have and that you need to verify before you acquire the property are liens that will follow the property. There are certain liens, like property tax liens, that don't follow the owner, they follow the property itself. So when you take title to the property, if, for example, there was $15,000 of property tax liens, you would actually be legally responsible for those liens once you took title to the property. And so it doesn't mean that you wouldn't necessarily buy the property, it just means you would have to factor in that additional $15,000 as part of your overall calculation. Now, obviously, properties that are sold at the trustee sale are sold at significant discounts, sometimes as much as 70 cents on the dollar. And so it still might make sense to go forward with the purchase. But you ought to know what you're getting yourself into. Thank you for joining me today, and I'll see you next time.